Let's talk about what we know so far in this case with National Trial Attorney Mike Jaafar, and he's in Michigan, and in Hawaii, homicide detectives extraordinary, Mr. Phil Waters. Michael, what's your take here? You have the situation where she calls police. She is concerned about her safety. That's why she calls multiple times, even as her kids call. And the responding officers say, all right, you go back in there. We can't do anything here. You people need to work it out. And she says, well, what if I shoot him in self-defense? It's in her mind already a scenario that she thinks might happen. And sure enough, he's dead a few minutes later. And she's claiming self-defense. How important is it for the state that she brought up self-defense before even going in there and shooting him?
This is the type of fact pattern that they would test you out in law school. They'd call it right down the middle, and it could go either way on the exam. When you submit your exam to your law school professor, whether you say she's guilty or whether you say she's innocent, you're right, depending on the merits of your arguments and how you explain the case. That's a tough one. In my opinion, these fact patterns usually cleave towards her being acquitted because the burden of proof is very high for the prosecution. If you're a juror and you say, hey, she committed murder, you can justify that decision because telling the police officers he's going to kill me and then walking out to your car, grabbing weapons, when you could easily just have left the house, he's not your husband, you know, you could leave the house.
She's got kids in the house. She's got a little...
Yeah, it's not exactly the easiest situation, but if you're convincing yourself that she committed murder, you could say she could have cooled off, she could have left. Her life was not an imminent threat. She was upset, but her life was not an imminent threat at that point. So that's why going out to the car and coming back in and then he dies is a big deal, because it's not that she came back in and then they had an altercation and then she shot him. She brought the weapons from her car that she used to kill him. So you could easily justify that she committed murder. Obviously, we have to see the balance of evidence that comes out in the trial, and when her testimony is going to be a big deal, she needs to testify now. But in my opinion, this one goes right down the middle.
And usually right down the middle means right out the door because of the reasonable doubt. So let's say she takes the stand. Michael says, I had the tire iron, I had the gun, and I'm using it to protect myself from him. Say stand back kind of thing. He says, don't, stop playing games, and then now lunges or comes at me. I've already been beaten by him before. He sends the text messages. You can say he's going to beat me. Is that self-defense? If he's lunging or coming at her, she already knows what it feels like to be beaten by this man. She'll testify to, likely. Is that now self-defense, or what do you think? Is it not enough? I mean, do you have to wait to get beaten up, or what is it? 2 hits, 3 hits? How many hits? How many times you got to get hit by a guy before you shoot him?
Yeah, I mean, we all unfortunately witnessed the Trayvon Martin trial when, a complete stranger killed a kid, who, he was able to prove to the jury he was beating me, right? So she doesn't exactly have to prove that there was a massive history or anything like that. That would be very helpful for her. But to answer your question, to prove to the jury that this was self-defense, in my opinion, it's enough to show that he was the aggressor and he knew she was holding a gun, and by him attacking her, knowing she had a gun, it was either kill or be killed. However, the testimony of that detective kind of tipped me over into the camp of she probably is going to get convicted of this, because there were no prior phone calls, there were no prior incidences with this person. He's on tape saying, stop playing games. She was manipulating her daughter after the fact. She did not exactly have an impassioned, emotional police interview. I know we didn't see the video on it, but from the audio, she did not have an impassioned plea that she was defending herself. She went outside. She talked to the police officers. She was gaming the system, asking them, what if I kill him in self-defense? He told the police officers, who have better instincts on these situations than any of us, told her, you're fine, go back in the house. And then she came back out, got the weapon, went back inside, and gamed this whole system. I've now been tipped over into the camp of she's going to be acquitted. She had bad hands. People, you have to understand something. It's not enough. We see this in movies, so some of us believe, hey, it's okay to kill a domestic abuser just because they're abusing you. That's not actually the case. You're not allowed to kill somebody who's abusing you. You have to really prove that you have been beaten multiple times. It's just to go up to somebody and kill them in cold blood. Murder them, not in self-defense, just to kill them in cold blood. You have to prove that there have been years upon years upon years of threats, you feeling you're in imminent danger. In the self-defense realm, you don't have to prove any of that, but you do have to prove that you felt that your life was an imminent threat, imminent harm of somebody about to kill you, right? She has to prove that. That's a mountain she has to climb. I don't think she can avoid testifying now because the overwhelming evidence against her is that she killed him in cold blood. So her defense has to prove to the jury that it was self-defense, and here's why. Here is the evidence that she was about to be murdered by this man, and she killed him to defend herself.
We shall see, because we do expect her to take the stand. We'll get a break here, see what Michael Sterling has in store on the cross-examination of the detective right after this. Now up to the defense. Michael Jaafar, Phil Waters watching along with us. Jury leaving the courtroom. Why? Does she not? I mean, she's going back to get her kids, right? Presumably, there's a 2-month-old baby, or a couple weeks old baby up there that he's been carrying around like a prop in front of the police. So she's got to go get the baby, obviously. All right. Well, one question to you, one answer, please, Michael. At this point, where we are, we've seen the state's case. Would you, if you're the defense, if you're Michael Sterling, bring her on and have her testify, yes or no?
Well, I don't know about that because you saw a major error by the prosecution there when the defense attorney asked the cop, do you need to be in, can you shoot somebody if they're charging at you? The prosecutor should have stood up and objected, asking to draw for a legal conclusion. You know, and he didn't do that. I wonder why. Those prosecutors did an awesome job. He should have objected to what the defense attorney asked, a line of question, because now it's admitted into evidence that, hey, the police officer, the detective, admitted that she could have shot him just by him lunging at her. So I don't know if I would bring her. It depends on the balance of their case, and depending on what they bring in, I'll be able to get a better sense of whether or not they should call her. But I don't think it's going well for her. But that was a big error by the prosecution. They should have objected to that, because then at that point there's no evidence that she could have shot the victim.
All right, let's get a quick break, and then we'll get back into the courtroom outside the presence of the jury. The defense has some arguments to make.